Introduction. The government's response fails to appreciate the seriousness and breadth of the issues raised by its violation of the pretrial notice statute. On the first page of its response, the government asserts that this court's original decision on the defense FISA motion was based on a review of the relevant material. RESP 1N.1. But that's not accurate. The government's supplemental notice effectively admits that the court should have received before trial the FISA Amendment Act (FAA) evidence that still has not been produced to the court. The incomplete pretrial notice resulted in incomplete production to the court of the material relevant to ruling on the pretrial motions to suppress. Throughout its response, the government evades the issues of great magnitude raised by its conduct by attempting to redefine the scope of yet-to-be-filed motions, while at the same time seeking to avoid providing the non-classified and classified material necessary for the defense to assess the scope and basis for substantive motions. The government asks the court to deny discovery based on vague, conclusory, and contradictory statements unsupported by any factual rebuttal of the powerful prima facie case that the government intentionally withheld from the court and the defense the use of FAA-derived evidence. This court correctly bifurcated the post-trial motions. Discovery first, then substantive motions, so the litigants would have a common basis in fact for the important issues the court must now resolve. The court should reject the government's crimped view of its failure to comply with the law, follow the outline of discovery issues in the defense memorandum, much of which is not disputed, and order the requested discovery. Page 1. Reply to government's response to motion for full discovery regarding the facts and circumstances underlying surveillance. Case 310-004755KI Document 496 filed February 27, 14 page A's of 35 page ID number 8765A. In order for the defense to present to the court the grounds for remedial action, and for the court to formulate its ruling, the substantive motions need to be based on discovery of the underlying non-classified and classified material related to the government's failure to file the required pretrial notice. In order to formulate the scope and basis for defense substantive motions for sanctions, suppression, and new trial related to the lack of pretrial notice, the defense moved, among other things, for disclosure of the following material documenting the government's failure to provide pretrial notice of surveillance pursuant to 50 U.S.C. paragraph 1881A, including, but not limited to, all communications manifesting any policy of non-disclosure and all communications underlying the decision to provide no notice and the decision to provide a supplemental notice. This material should at least answer the following questions. Who had knowledge that paragraph 1881A surveillance was implicated in this case, and when was such knowledge gained? Who was involved in any decision not to provide pretrial notice of paragraph 1881A surveillance, and when was such a decision made? What justification, if any, was relied upon in any decision not to provide pretrial notice of paragraph 1881A surveillance, and what led to the filing of the supplemental notice? What, if any, notice was this court given about paragraph 1881A surveillance relative to Mohammed or other persons relevant to this case prior to trial? In telling the court that no discovery should be provided addressing any of these questions, the government relies on vague, conclusory, and contradictory statements, unsupported by any affidavits or declarations, that are inconsistent with reported statements to the press apparently from individuals within the Department of Justice, DOJ. The court should reject these attempts to avoid accountability for a serious violation of the statutory notice requirement. The Rule 16 obligation to page 2 reply to government's response to motion for full discovery regarding the facts and circumstances underlying surveillance case 310-CR00475KI Document 496 filed February 27, 14 page 9 of 35 page ID number 8766 provide documents, material to preparing the defense, and the constitutional Brady obligation to provide material favorable to the defense. 1. The government's vague claims regarding the failure to provide pretrial FAA notice are conclusory, contradictory, and inconsistent with reported statements. The core of the government's claim regarding its failure to provide statutorily required notice is that the department had never thought of warrantless FAA surveillance under Title VII leading to Title I and Title III surveillance. Prior to recent months, however, the department had not considered the particular question of whether and under what circumstances information obtained through electronic surveillance under Title I or physical search under Title III could also be derived from prior collection under Title VII. RESP. At 7, emphasis added. Point 1. The government's claim that it was unaware that the fruit of the poisonous tree doctrine applied to warrantless Title VII surveillance strains credulity. See United States v. Giordano, 416 U.S. 505, 533, 1974, suppressing later electronic surveillance derived from earlier illegal wiretapping. Wong Sun v. United States, 371 U.S. 471, 488, 1963, requiring suppression of evidence, committed by the exploitation of a primary illegality. Silverthorne Lumber Company v. United States, 251 U.S. 385, 392, 1920, insulation of the government's use of knowledge gained from an unlawful search would reduce the Fourth Amendment to a mere form of words. But in this specific case, the defense placed the government on notice of this precise issue, both by citing to paragraph 1881A and by asserting concern that earlier warrantless surveillance led to the FISA surveillance. CR 489 at 4546. 1. Curiously, the government injects a new label of the department at the stage of the brief, instead of the government, as was used in most of the brief and throughout this case. The court should reject any attempt to artificially separate government agencies, especially given that they all work in tandem on national security issues and, in fact, are all part of the definition of intelligence community under FISA 50 U.S.C. paragraph 1885-7. Page 3. Reply to government's response to motion for full discovery regarding the facts and circumstances underlying surveillance. Case 310-CR00475-KI Document 496 filed February 27, 14 page 10 of 35 page ID number 8767. The government's artful drafting regarding the Title VII surveillance avoids giving the court and the defense and the public the true facts of the case. After stating that the department had not considered the question of derivative use of Title VII surveillance and deriding reference to a secret policy on such surveillance, the government asserts that the prosecutors acted in accordance with the department's then current standard practice that only Title I and III notice need be given. Resp. At 8. Is the government asserting that there is a meaningful difference between a non-public, standard practice and a secret policy? Does this mean the prosecutors were aware of the Title VII surveillance but made an intentional decision not to provide notice under the standard practice? Or did the NSA or other intelligence agency fail to provide Title VII information to prosecutors in accordance with the agency's internal policy and practice? And how does the government not have pretrial notice that Title I and III surveillance could also be considered to be derived from prior collection under Title VII when the defense FISA motion explicitly referenced warrantless surveillance leading to FISA warrants? Even if the government did not independently consider the derivative use of FAA surveillance to generate FISA warrants, the defense explicitly put the question into the case. The government's claim of a standard practice is inconsistent with its claim that the question being not considered. A standard practice cannot be formulated without considering the question at issue. The government provides no response to the public reports that contradict its denial it ever considered whether the fruit of the poisonous tree doctrine applies to Title VII. Media reports assert that there was indeed a governmental policy of non-disclosure regarding FAA surveillance that led to FISA warrants. CR 489 at 910. Whether the policy of non-disclosure, page 4. Reply to government's response to motion for full discovery regarding the facts and circumstances underlying surveillance. Case 310 CR 00475-KI Document 496 filed February 27, 14 page 11 of 35 page ID number 8768 extended to the court is not explicitly addressed. 2. The prima facie case that the media reports are true comes from both the statements attributed to several Obama administration officials familiar with the deliberations and the chronology of public events that led to the post-trial notice. The government appears to deny that the post-trial notice resulted from the fallout after Clapper v. Amnesty INTL USA 133S.CT 1138, 2013, affirmatively asserting that the case has no bearing here. Resp. At 8N.4. But in discussing Clapper, the government states that its previous and current understanding is that the statute requires notice of the intent to use or disclose information that was derived from Title VII collection as well as information that was obtained from Title VII collection. This statement contradicts the assertion that the fruit of the poisonous tree doctrine and Title VII were not considered. Resp. At 7. And the claim that the prosecution acted in accordance with the department's then current standard practice. Resp. At 8. The government's confusing, contradictory, and inconsistent positions demonstrate why discovery and review of the actual facts is appropriate. There are non-classified and classified materials that answer the questions that discovery should answer. If there is a claim of privilege or classification for some material, procedures are available for the court to access the material and allow its production to the defense under appropriate protective orders or under the safeguards set to. Because the government's response to the pretrial FISA motion was heavily redacted, the defense had no way of knowing if the Title VII issue was addressed in ex parte and in-camera filings. The government's response to the post-trial discovery motion appears to concede for the first time that the government withheld the FAA notice from the court as well as the defense. Resp. At 3-4-15-18, before trial, in the unclassified context, the government asserted that, other than the non-FISA computer search, the defense is aware of all the court-authorized search and surveillance that occurred in this case, then added, if the question is information about warrantless searches or surveillance, again, they have everything. CR 58 at 63-64. The requested discovery should disclose whether the court received similar assurances in the classified context. Page 5. Reply to government's response to motion for full discovery regarding the facts and circumstances underlying surveillance. Case 310-CR00475-KI Document 496 filed February 27, 14 page 12 of 35 page ID number 8769 out in the Classified Information Procedures Act. Just as the Supreme Court has long rejected reliance on conclusory statements, even with an affidavit, to support probable cause determinations. 3. The court should insist on the underlying facts in the form of documents demonstrating who knew what when. CR 489 at 13. The court should not accept selective or summary accounts of the underlying facts. The primary sources and the inferences to be drawn from them should be subject to full adversary proceedings, whether or not the proceedings are sealed. Rather than accepting conclusory assertions, the court should rely on sworn affidavits and primary source documents providing complete and detailed accounts of the circumstances surrounding the statutory and constitutional violations. To the extent material is controverted, the court should resolve factual disputes with testimony subject to cross-examination and full discovery of the relevant underlying information. 2. The government's injection of prosecutorial misconduct and bad faith as the relevant standards for discovery is inconsistent with the defense motion and puts the cart before the horse. The government seeks to bootstrap its discovery response by claiming that the discovery motion asserts prosecutorial misconduct and, therefore, the court should apply the restrictive discovery standard for selective prosecution claims based on the Equal Protection Clause. RESP 9N.5. The discovery motion never used the term prosecutorial misconduct. Instead, the motion pointed out the critical importance of knowing who did what when and why in order to determine the potential basis for substantive motions. CR 489 at 1016. This litigation implicates the 3C Gates v. Illinois, 462 U.S. 213, 239, 1983. A mere conclusory statement without sufficient underlying facts for the judge to make an independent determination is insufficient to establish probable cause, citing Nathanson v. United States, 290 U.S. 41, 1933. Page 6 reply to government's response to motion for full discovery regarding the facts and circumstances underlying surveillance. Case 310-00475-KI document 496 filed February 27, 14 page 13 of 35 page ID number 8770 fundamental rule of law regarding the disclosure of governmental conduct and its evaluation by the independent judiciary through adversary proceedings. As President Obama stated, given the unique power of the state, it is not enough for leaders to say, "Trust us, we won't abuse the data we collect." Our system of government is built on the premise that our liberty cannot depend on the good intentions of those in power. It depends on the law to constrain those in power. The White House, remarks by the President on review of signals intelligence, January 17, 2014, emphasis added. Point 4. Our liberties cannot be safeguarded if the independent judiciary, the only effective check on executive power in the context of the individual, depends on conclusory claims of good intentions to foreclose the disclosure of information necessary to assert individual rights. First, the government is putting the cart before the horse. The defense asserts the sequence of events and the reported facts are troubling, but requests discovery in order to allow the arguments to be based on facts rather than speculation. CR 489 at 1. Once the facts are known, the defense can formulate its arguments on the substantive motions, including what inferences should be drawn from the evidence. The government's attempt to conflate the discovery motion and the substantive issues should be rejected. First, discovery of facts, then motions based on the evidence produced. Second, the government's reliance on selective prosecution law in United States v. Armstrong, 517 U.S. 456, 1996, is misplaced because that case dealt with prosecutorial discretion, not a prosecutorial obligation. In Armstrong, the defense asserted that the prosecution was racially motivated and that the defendant should receive discovery regarding charging practices in support of a claim of selective prosecution. The court relies strictly on cases involving the wide berth given for available at http://www.whitehouse.gov/-press-office/2014/01/17/remarks-president-review signals intelligence. Page 7 reply to government's response to motion for full discovery regarding the facts and circumstances underlying surveillance. Case 310-00475-KI